you pick up the videotape for that day. And I also failed to mention that the arbitrations will be held here at the Chicago Bar. That's not mandatory, but we think in most cases that's going to be the easiest way to schedule these. So the default is that we will schedule those here unless there's a reason to do it elsewhere. Okay. We'll now turn to Judge Evans, who will talk about the court's role in these arbitrations.
Thank you very much, Linda Rio, my colleagues at the dais, ladies and gentlemen. I'm here this afternoon for a couple of purposes. The most important one is to thank you for your willingness to take on this task. And I'd like to put this in the context of a larger procedure so that you'll know where you fit in to all of this. Last year, the state legislature decided in its wisdom to level the playing field. That's what the legislation was called. To put men and women involved in this kind of dispute on the same level. What kind of dispute am I talking about? Primarily domestic relations activities. Families that are breaking up. Those weddings that were made in heaven. Someone has discovered that actually they may have been made somewhere else, a little lower. The emotions are as high in these cases as you might find in any family where a tragedy has occurred. A marriage breaking up is as traumatic as a death in the family. It is literally the death of a marriage. And so, on average, the Domestic Relations Division, not counting the parentage cases where the families were never married, not counting those, but on average we would have something like 26,000 divorces a year. And every one of those 26,000 cases are cases potentially where there could be a dispute involving a client and a lawyer. And in the past, before you, the judges and the Domestic Relations Division had to deal with every one of those cases. Well, in this legislation, there was a provision that said before there could be a trial between a lawyer and a client dealing with attorney's fees, there had to be some kind of alternative dispute resolution attempted. Sounded great, wonderful. We looked in the legislation and we were trying to see where was the money for the ADR. Nowhere there. Well, what about who could serve as a mediator? Surely that would be there. Not there. Does that mean that the average minister could serve as a mediator and come back and say, Judge Evans, we've helped to resolve this case? Yes. Sometimes with no training, sometimes well-meaning, but nevertheless not resolving these issues amicably, legally, and fairly. So, what do? As judges, we turn to the bar, to many of you, and we ask, could we put an additional burden on you? Are we going to make you rich? No. Will your neighbors appreciate it? Yes. Do we absolutely need it? Yes. Is it public service? Yes. And that's what I want to really underline here. I consider public service to be a high and noble undertaking. And you are entering this venture with that in mind. The judges in the Domestic Relations Division will now rely on you your good judgment, your logic, your temperament, to come up with something that we can enter as an order. We will be taking your work, incorporating it into an order, and we will be enforcing your work. That's just how important it is. And if a client doesn't feel that that client has gotten from the lawyer what the client should have gotten, you'll have to determine that. If the lawyer has performed as ably as that lawyer was supposed to perform, and that lawyer is entitled to the fee, you will have to determine that. Nobody can leave. I'm going to lock that door. Mediation, yes, it's important. We suspect, and we'll be taking the statistics and we'll find out, we suspect that the natural embrace in a conflict between lawyer and client on money will be mediation, because there's no fee. Does that mean that all of the cases are going to be resolved by mediation? No. We're finding out already that those who want to have an end to this debate sometimes prefer binding arbitration. So your work, if you decide to become an arbitrator, your work literally will be the end of that particular debate. So yes, it is important that you take this job seriously. How will it get to you? Let me explain that briefly. After virtually all the other issues have been resolved, the child support, the custody, the visitation, all of those issues have been resolved, it's at that point that we expect that a debate might arise concerning the fees between the lawyer and the client. And they're going to file a petition saying, Judge Evans or Judge X, we want you to resolve this issue. And we're going to say, well, we might have to do that. But first, you're going to be going to alternative dispute resolution. And we're going to recommend your system to the litigants who will be appearing before us. And we're going to give them a status date to report back to us, letting us know that they have applied to this system, and where they have chosen binding arbitration, that they have paid what they're supposed to pay. And they will come back to us on that status day and report to us that they have done what they're supposed to do. And we will then send them back to you, and we will await your decision. Now, there will be various stages of this. There will be a stage where the litigant and the lawyer will say, hey, Judge, we're not mad at each other. In fact, I want this lawyer to continue to represent me on something else. We just can't agree on the fees in this particular case. And under our procedures, it will be possible, if they wish to mediate the case, for us to send them to you without the relationship of lawyer-client being removed, if that is their choice. But we will have to inform them that they have a right to a hearing, that they have a right to be present at the hearing, that they have a right to be represented by a separate lawyer in this particular proceeding. And if they choose to, they have the right to have their current lawyer removed from representing them, or have that lawyer simply step down. And they will have the right to see the engagement agreement that they entered into between themselves and the lawyer. And most importantly, they will have a right to see the time spent on that case by that lawyer and what was done by the lawyer for the money. So they will have all of that when they come to you. And you'll have an opportunity to review all of that. And if the case is mediated successfully and they come back to us and they say, Judge, we reached an agreement. We'll incorporate that agreement into an order, and we'll enter that order. If it's binding arbitration, no question about it. They're going to be bound by your decision. They'll bring that decision back. We'll incorporate that into an order. We'll enter that order, and it will become a judgment based upon your work. Now, if they choose mediation and they don't reach an agreement, the case must come back to the judge, and we must still conduct a full-blown trial. So in those instances, your good work may not be the end of it. But if you serve as a mediator and your work does not result in an agreement, don't be discouraged, because frequently what that will do is that will give them a chance to have the animosity dissipate. They will know what the other side can present in a full-blown hearing before the judge. They will know that no client is going to be represented free, and the lawyer who didn't do any work is not going to get paid for work that he didn't do. And frequently that in and of itself will lead to an agreement without a full-blown trial. Now lastly, we may not get a chance to thank each one of you individually for what you do. And I hope you will permit me to represent, as I stand here, the 40 judges who work in the division, as I say to you, that if we can spend the judicial time that we have to spend trying to get the children out of the line of fire, if we can spend that time reminding the litigants that they are not only litigants, but they are parents too, if we can remind them that our system is set up not so somebody can leave saying, hey, I won, but so it can be the result of an equitable division in property. If we can spend our time on that, while you spend your time on these matters, we will be eternally grateful. People will respect the judicial system more than they do right now. They will respect the legal community more than they do right now. And those of you who are not lawyers will be able to go back into your communities and give your colleagues, your neighbors, and your friends some sense of what lawyers really do. The lawyers who sit in here are frequently too modest to say what they do. The newspaper articles that you read about what lawyers do, I assure you, often represent an aberration of the process. You read about those who have not done what they should have done, but you don't get a chance to see the ones who are with us day in and day out, working sometimes as GALs for children, getting no money. I was in a case the other day where we finished at 10 minutes to 1 in the morning. We resolved it, one of the biggest cases in our division. But you didn't read about that in the newspapers. The lawyers were not on the 10 o'clock news taking a bow. But the family involved that had not spoken among themselves in close to 5 years left arm in arm. And the children respected their parents again. We were able to move on to the next contested case. I thank you for what you're doing. I want you to know that our door will be open. This is not the end. This is the beginning. And so if your good suggestions find their way to my desk, I will try my best to incorporate them so that we can have a better system as we go forward. Thank you very, very much for listening to me.
Thank you, Judge. Now you all know why the Domestic Relations Division is in such good hands these days. David Pasulka is going to talk to us about the underlying cases that Judge Evans was just referring to and the fees involved in those cases. David?
Thank you, Linda. When I look out at the crowd here of people who are willing to get involved, when I look at the committees that have been put together, Linda Rio, Lynn Gaffigan, Jack Cooley, Eddie. It's amazing. All I can say is, wow. Thanks for being here. When I look over at Tim Evans, I'm not so impressed because I'm starting to get used to the wow that I always gave him. Whatever bar group functions we're doing, whatever we're trying to get accomplished for the good of the Domestic Relations Division, Tim Evans is there whenever we need him. He helps us, he works with us, he gets things pushed through. When Tim said that he was there till 1:45 on a case, he was being modest. It was a lot closer to 1:30. In fact, I have the billing statements that prove it. I was talking to Tim complaining about judges who ramble on in their opinions, and I think I overdid it because I think he heard enough of me, and 2 days later I appeared in front of him on a fee petition, and the client was saying I wasn't entitled to any fees at all. I argued my case, and I got a little dramatic at the end, and I said, with God as my judge, I'm entitled to my fees. Tim took to heart what I said about rambling opinions, so his opinion read, he's not, I am, you're not, judgment for the client. But seriously, I want to take the opportunity. We were just at a big retention gathering for the judges trying to be retained. We have wonderful judges in the division. We have judges like Tim Evans, who it's quite unfortunate that our judges have to worry about being retained and have to worry about what's going on in Washington. So encourage everybody, come on out and vote. Getting on to what I'm talking about with respect to how do you apply the law to the fee petitions, and there'll be a mock trial coming up next week on this with respect to a fee petition that's in your packet. I'm going to first of all make it very easy for you. Everything that I say here is in my handout with respect to Illinois law on attorney's fees. I've taken out anything that, I've tried to take out most of the things that simply don't apply here. I'm going to go through it quickly. The cases are all there. Everything that I'm saying is all in your packet. I think you should read all of this closely before you do a mediation if you're not familiar. The divorce attorneys are a little more familiar with the law on fees. Some of them probably tired of hearing me preach about it. It's real simple. It comes down to two words, reasonable and necessary. So as you listen to a fee hearing, as you look at the time records, on each entry, on each task that was performed, you ask yourself, was it reasonable? Was it necessary? If your answer is yes, award the fees. The case law on fees, and by the way, because there might be a problem with an entry in a time record, that doesn't preclude the person at the hearing from explaining it, from shoring it up, from being more specific as to what the specific task was that he did. I'm going to talk about a lot of the problems that you might see in fee petitions, but remember, in trying to mediate or arbitrate these, this isn't a perfectionist contest. Could the attorney have been more perfect in how he described his work? Simply, can I ascertain what, in the overall scheme, was this task that they performed reasonable and was it necessary? Along those lines, time records have to be very specific. The lawyer should have who performed the task, what the task was, how long the task took, and that should be spelled out in the time records. If they say, I reviewed the file, had a conference with the client, that doesn't really tell you anything. If it says telephone conference with the client, half an hour, now you have to reflect, is it reasonable? Is it necessary? Well, gee, I don't know. What did they talk about? Were they talking about Mark McGuire and Sammy Sosa? Probably not compensable. If they were talking about tomorrow's pretrial and what to expect and how we were going to strategize it, then it probably was reasonable. So the more specific the time records are or the testimony is, the easier it is to make that determination as to whether the fees are reasonable. Again, along the line of research. Research, 5 hours. Well, what did you research? Why did you research it? If you're charging at a high rate, are you entitled to, aren't they paying for a certain modicum of expertise? But again, on the other side of it, that's not to say that we don't have to get out the law books to make sure of what the law is or to look up the latest cases. So it has to be a weighing factor. But the whole point is it shouldn't be your job to try to piece together all of the fragments and try to figure out for this lawyer how much they're entitled to. It's the attorney's job to present the fee petition. If you're talking about conferences, whether they're inter-office conferences, conferences with clients, you have to be specific. If you're talking about intra-office conferences or inter-office conferences, you have to ask yourself, why are these two lawyers from the same firm talking to each other? Do they need to be doing that? Is this over a lunch and so they've got to figure out a way to pay for the lunch? Is it something where they're just coordinating their efforts for the good of the client, or is it something where they're duplicating services? Sometimes that might be an acceptable entry if one of the lawyers charged for the conference, but not both. It seems to be the pattern that they're both not allowed to do incessant conferencing within a law firm. If you revise a document, I guess the question is, why didn't you get it right the first time? If the records reflect that, then you have your answer. So if the records show why a revision was necessary, then you may be able to say, I see why it was necessary, I determine that it is reasonable. But without explanation, that may leave that open and open for you to have to try to guess, and that's not really your job. But again, simply because it says revising the document doesn't mean it's not a valid time entry. Reviewing the documents is one of the areas that you really have to watch. It's a suspect class because you often see review petition for dissolution of marriage. And 3 days later, 5 days later, you see prepare response to petition for dissolution of marriage. Well, you attack the review the petition. Well, wasn't I supposed to review it? Well, didn't you review it again as part of your process in preparing the response? But what happens also is you get into the minimum charges. Point 2, review letter from opposing counsel. Well, that's 12 minutes. Some letters do take 12 minutes or longer to read. I'd suggest most letters take about 3 minutes at best to read. But it's an area where you don't want to overdo it, but on the other hand, you should be alert to that area. That is one area where excessive fees can be tucked in. Again, there's no per se prohibition, though, for billing for reviewing, and in fact, the important documents in the file better be reviewed. Routine and administrative matters are always a suspect class. Were you talking to the client about a problem that the client had with your bill? You probably shouldn't be billing for it. When the other side or the client reported you to the ARDC, did you bill them for your response? It happened in a case. Appellate court said no. Sometimes you see went to court to file petition for dissolution of marriage. A lawyer shouldn't be charging to file a petition for dissolution of marriage. Somebody should be doing that. The Kaiser case basically says that a lot of those functions are your office overhead. And we'll get into some of the costs like postage and things like that. The courts have determined that unless you have very specific contracts that take into consideration these things, this is part of the office overhead. This is why we charge a lot more than plumbers. If your rates are high enough, it should have encompassed your overhead in the case. Or if a rate is a reasonable customary rate, it should encompass some of that overhead. Travel time is a suspect class. In reviewing the cases, travel time is allowed in certain circumstances. But for an attorney to go from the county line to the Daly Center and bill for it leaves a real open question. Whether or not to walk 10 minutes to the courthouse or not is a different issue. If you're going to have travel time involved, there should really be a very specific contract behind it saying, I've warned you that I'm a long way from the courthouse. I'd advised you could hire other people, and you wanted to hire me anyway. What I would suggest is you're rarely going to see something like that, so keep your eye on whether the travel time that you run into is reasonable and necessary. Duplication of efforts, again, watch that. But on the other hand, The Harris Bank case that's in your packet says that a 12-minute conference between the attorney and his supervising partner for review of a court hearing memorandum didn't involve unreasonable duplication of efforts. So again, there's really nothing in here where you can say, aha, I remember something about duplication or reviewing, and therefore I can't allow those fees. That's not what I'm suggesting at all. Keep an open eye toward it is all I'm saying. In your hearings, you may get into issues of whether the time records were kept contemporaneously with the services performed. The court originally had come down and said they must be kept contemporaneously. Then some of the decisions started sliding into the word simultaneously, which really opened up questions in certain circumstances. That whole standard has been relaxed. They don't have to be kept contemporaneously. You can look at telephone bills, logs, diaries, and piece together your time, and that would be acceptable. But on the other hand, having said that, many, many cases come back and say the courts much prefer contemporaneous records because they're a lot more accurate, and you have a lot more accurate basis as to to award fees. The other thing is that watch for the billing. Under the new act, the client is supposed to be billed with a detailed bill at least quarterly. If they're not doing that, it may create a problem. The converse, I think, is true also. If an attorney regularly sends bills, sends them on a monthly basis, let's say, and sends detailed bills, it's incumbent under the Statement of Rights and Responsibilities of the client to look at the bills, to call and ask questions if they have problems with the bills. It puts a lawyer in an unfair advantage when 3 years later the client for the first time raises an issue on bills when they've been receiving these bills regularly. If under the new statute there is a presumption that if there was no objections, that these bills would be deemed reasonable. Having said that, that really meshes against a lot of case law that says, no, the lawyer still always has the burden of proving reasonable fees. My guess is if I had to bet that the law would be that way and that the lawyer would still have the burden of proof, the presumptiveness doesn't shift the burden to the client to show unreasonableness of the fees. Ultimately, you may end up there in a fee hearing anyway with the client raising various issues. But I think in general, the benefit of the doubt on questionable issues should be given to the lawyer if the bills were sent in great detail and sent very regularly. Keep in mind, too, one of the things that arises often in fee disputes is a raise of the attorney's rates. The law is that we owe a fiduciary duty to our clients. So before the client decides to retain me, before I decide to be hired by the client, I'm at an arm's length transaction. The client can walk out of the office if they don't want to sign my retainer agreement. I can decline representation of